In this video, I'll be doing some extended commentary of my How to Start a Business video from the perspective of legal matters that you might have to consider. Since this video explicitly focuses on legal matters, I should emphasize that I am not a lawyer. I am a software engineer. This video is not legal advice. For actual legal advice, consult with an actual lawyer. Now, of all the things that I can talk about in this video, I think one of the most important things that you need to understand is the difference between criminal law and civil law. Now, for the purposes of this video is mostly going to focus on civil law because many of the rules for criminal law and civil law are completely different. Now, one of the main features of civil law is that it comes with exactly that assumption. It assumes that civil legal matters can be resolved in a polite and civil manner. And this is contrasted with criminal law, where criminal legal matters are less likely to be resolved in a polite manner, and they may require the use of force by the authorities. Now, that one is a pretty obvious difference that you probably already knew about, but for the purpose of this video, one difference that you probably didn't know about is where the burden of enforcement is. So if you've never been through the process of suing someone in civil court before, you might be under the impression that if someone violated your business contract and owes you money or something, that you can just go to the court, you tell them what happened, and then the big bad court will go chase after them and get the money for you. And that is absolutely not the way it works at all. So in the context of civil law, the burden of enforcement is completely on the plaintiff, and in some cases the defendant. And when I say burden, what I mean is the costs associated with pursuing that legal action, all the work of filing the forms, the work of going out and trying to track down the person who wronged you, and this is contrasted with criminal law, where the burden of enforcement is on the state or on the crown, so basically the government. And in a similar vein to the last difference, it's important to emphasize that in civil cases, a case will only start if one or both of the private parties involved take formal steps to initiate one. So in other words, if I do up a business contract to sell someone something and the other party rips me off, nothing will actually happen about it unless I go to the court and formally file a claim against them. And of course, in criminal law, it works the other way for obvious reasons. Laws for things like murder wouldn't work very well if the person that you murdered needed to actually sue you in order for you to be prosecuted. Having said that, in addition to a criminal case that's brought forward by the state or the crown, you can also have an additional separate civil case that's brought forward by one of the private parties involved. If you want to start a business, it's extremely important that you understand this distinction between civil and criminal law. If you do end up needing to find legal counsel for your business, it's important that you hire the right type of lawyer. If you hire a lawyer that focuses on criminal law, don't expect them to understand very much about civil law. And the same thing goes the other way too. Another thing that's worth saying about this distinction between civil and criminal law is that most civil matters will stay as purely civil matters. However, there are some cases where if you break some of the rules during a civil legal proceeding, the consequences could end up moving you into criminal law. For example, if you're formally served and you're supposed to show up to court, but you don't show up, the result will be a contempt of court hearing, where you're supposed to show up and explain why you didn't show up to the other hearing. If you don't show up to the contempt hearing, the result could be criminal penalties. However, in my experience, judges are extremely reluctant to issue criminal penalties for things that start out as civil matters. This distinction between criminal and civil law is also important to keep in mind when reporting things to the police. Members of the public often get frustrated when they report things to the police and then find that the police say they can't do anything about it because it's a civil matter. In these cases, people may say that the police don't care or that they don't want to do anything. But in reality, it's not necessarily that they don't care, it's just that it's not their job to handle civil legal matters. And to make matters worse, sometimes this distinction between criminal and civil law can get blurry when there's a contract involved with a particularly bad business. So next, I'll do a quick review of some of the legal terms from the video. And as you can see, the first one here is this section on indemnification. And as you can see from the description here, the meaning is just about compensating one of the parties if there's something like an unexpected loss. And the concept itself is not super complicated, but my reason for including it in the video is just that it's a very common section that you will see in a lot of business contracts. But in everyday spoken English, you will almost never see this word. And if you do see a section like this in any kind of business contract that you're agreeing to, you should skim it over quickly just to make sure that you're not indemnifying the other party for something crazy that you can't possibly uphold. Now, force majeure is another common legal term that's worth knowing about. Depending on what your business contract is about, if your line of business can be heavily impacted by things like natural disasters or unexpected events, this is something that you might see invoked on some of your contracts at some point in life. So the basic idea behind force majeure is it's just a term that you can invoke to escape liability and obligation whenever there's some sort of very rare event that you can't control, such as wars and pandemics and such. Now, the next term from the video is binding arbitration. So by default, if you enter into a business contract with someone and there's some sort of a dispute, you can file against them in civil court. However, that can be very expensive and time-consuming. So sometimes the parties involved in the contract will agree to do binding arbitration instead. And the idea behind binding arbitration is it's supposed to be a much faster and less expensive process. However, the rules for binding arbitration can be different, and whether it's better or worse probably depends on who's actually doing the arbitration. I've heard of some people saying that agreeing to binding arbitration was the worst thing that they ever did, and others said it was the best thing that they ever did. So if you see this section in your contract, make sure you read up on the arbitration process. Now, this section on non-exclusivity and assignability is very important if you want to be an independent contractor or consultant. So really, there's two completely separate concepts being expressed in this bold section here. So non-exclusivity just means that the contract is not exclusive. So this contract for services is not just for this one customer, you're allowed to use the same contract with other customers as well. And if you want to watch another video that's very related to this concept, check out my Contractor or Employee Know the Difference video. And the second part of this clause is for assignability of the contract. And that's extremely relevant if you want to assign the work that's actually going to be done to someone else in another company. Now, of course, if you run a large company, the person signing the contract is probably not the same person actually doing the work, so the concept of assignability is not really relevant if it's just another employee at the same company. But if you want to subcontract the entire thing out to an entirely different company and just pay them some fixed rate to do the work and then act as a middleman and take some profit, the ability to assign the contract to someone else is very important. Now, the next section here shows a termination clause. And the purpose of this section is just to describe what exactly happens when the contract unexpectedly ends early. And if you write up a contract to go into business with someone, I would say this is one of the most overlooked and underappreciated sections that you can actually have. Most people will go into a business contract with a fairly optimistic mindset. They assume that everything's just going to work out fine. Because of course, if you thought that they weren't going to work out fine, you wouldn't enter into the contract in the first place. So it's easy to overlook the importance of having a good termination clause, because neither party is likely expecting the business relationship to end early. And if you don't plan out the early termination in advance, there's an extremely high likelihood that you'll disagree on how something should be settled. If you hire someone to do a renovation job, and they only do half of the work and then quit, they might expect to be paid for half of the work, but from your perspective, you might not want to pay them anything, because a half-completed project is probably more difficult to get restarted, and the person that you hire to finish the job might want additional compensation for working on a difficult half-finished project. And the last section from the video is on governing law and jurisdiction. The concept of a jurisdiction is very important, and it was also mentioned in my last video on accounting commentary, which you should also check out, because there's a lot of overlap between these accounting concepts and the legal concepts. And as I mentioned in the last video, the concept of a jurisdiction is extremely important, since the jurisdiction determines which sets of rules and laws you have to follow. And from the How to Start a Business video, you can see that I've set the jurisdiction to the Sovereign Principality of Sealand, which is of course comical because this is an independent micronation that doesn't actually have any courts or anything. And for the most part, when you're signing or writing a contract, the exact jurisdiction that you use isn't necessarily that important, as long as it's set to something specific and reasonable, and at least one of you live or do business there. One common mistake you can make is not specifying any governing jurisdiction at all. So then when it comes time to actually dispute the contract, you'll find that that becomes difficult, since the exact definitions of various legal terms often depend on what jurisdiction you're in. And if you don't know what the jurisdiction is, how do you figure out the definition? So next, I'll talk about a few more important legal terms that you should be aware of, one of which is a default judgment. The best way to describe what a default judgment is to imagine a scenario where you sue someone who owes you some money, and for the sake of argument, assume that this person who owes you money is going out of business. Now, a pretty common thing that happens in this kind of scenario is the business owner will sometimes just walk away. They might be totally overwhelmed with stress, and they decide that the whole business model is just not viable, and then they just stop answering phone calls and stop opening their mail. And in that scenario, if you sue them for money that they owe you, and you properly serve them and everything, and then they decide to simply not even respond to your court filing, then you win by default, and that's called a default judgment. So in that case, the court will simply side with whatever claim you made. So in this case, you don't have to go to trial or anything, and once you have the default judgment, you can start to actually try to enforce it. So that means you can start to take formal legal action to try and get your money back, either by seizing some of their assets or garnishing their bank account. Now, as I mentioned a moment ago, the concept of a jurisdiction is incredibly important. And as you can see here, the way that a default judgment works in practice depends on the jurisdiction. But if you take a look at this article that talks about enforcement of foreign judgments, you can see down here, where it talks about the United States, that New York and Connecticut are two of a small minority of U.S. jurisdictions that do not simply allow a judgment creditor to file a foreign judgment from a sister state if the judgment was obtained by default. So based on my understanding of this, I would interpret this to mean that if you filed a case in a California court against a company that was in New York, and you obtained a default judgment against that company, then you would not easily be able to enforce that default judgment. However, from researching this for only a couple of minutes, it seems like the reverse may not be true, because it seems like in California, you can simply file this form to have a default judgment in a foreign jurisdiction recognized. So clearly, getting the jurisdiction right can be very important for certain cases. But of course, don't take legal advice from a software engineer. Talk to an actual lawyer. Most likely, the reason for not simply accepting default judgments from a foreign jurisdiction is done to cut back on fraud and nuisance lawsuits. Another legal term that's worth knowing about is liquidated damages. So in a simple suit, if someone is suing for damages or lost revenue that has a very obvious fixed value, the process of figuring out the damages and the final judgment is very easy. However, in other cases, if someone is suing for damages to something intangible, like damage to their reputation, they might claim that the damages are on the order of $1 million in value, but the other party might claim that the damages have zero value, and the process of liquidating the damages means finding out what the actual damage amount is, which usually involves the opinion of a judge. Another very important legal term that you may never have heard of is serving of documents. If you file a suit against someone, the court will send a copy to the address that you indicated. But as the plaintiff, you'll be personally responsible for delivering a copy of the court notice to the defendant as well. And generally speaking, it does make sense that the court does it this way, since you're more likely than the court to actually know where to find this person. The process of so-called serving documents is an extremely important formal process. Formally serving the other party with documents is something that you'll likely have to do multiple times throughout a court process. If you don't formally serve the other party with documents, this can cause you huge problems, and it can also make you lose the case. Things like sending a reminder email or a telephone call most likely won't count as formal service. And if you do use alternate methods of service, you'll have to go above and beyond to convince the judge that you've adequately tried to serve the other party. In many cases, if you sue someone in court, they won't be very happy to see you. And for this reason, if you have to formally serve someone, you might end up playing a game of hide and seek, where the person tries to evade being formally served, even though they know that they actually have a court date coming up. The reason that they do this is because they know that if they can avoid being formally served, then they can show up to court and say, "Oh, I didn't get that notice. I was never served with this or that," since this would give them a justification to delay the process, or possibly even get the case dismissed. For this reason, the concept of a process server exists. Effectively, this is similar to any other courier service that you'd hire to send packages. Since the process of trying to serve someone can be difficult, it can be a significant accomplishment to successfully do so. If you've ever wondered where the phrase "you've been served" came from, this is it. Next, I'll say a bit about my experiences in retaining a lawyer's services to do a bit of work for me. After about 1.5 years of running my business, I had a bit of extra money, so I decided to reach out to a lawyer to get a formal legal contract for my consulting services. I gave him a few descriptions of the types of clients that I had had, and what exactly I was looking for in a legal contract. I repeatedly emphasized to him that a generic template contract was probably good enough, and that I didn't need to get one written from scratch. Despite this, I do believe that they wrote my 14-page contract from scratch. I believe that this is the case because when I first got the contract, it had red underlined typos in it. On the email thread where they provided me with the contract, I noticed someone else's name involved in the conversation, and from the conversation that I saw, it looked like they were probably an intern. For this business contract template, the lawyer charged me about $1,500 in 2015 or so. To you, that probably sounds very expensive, But just like I said in the accounting video, professional services can be very expensive. And often, the firms that provide these sources have a substantial markup over the hourly rate that they actually pay the employee who does the work. The person who did this work probably got paid less than $500 to do so. Generally speaking, it's not uncommon for a lawyer's consulting rate to be on the order of $300 per hour. For extremely specialized services, it could be as much as $600 to $1,000 an hour. The next thing that I'll talk briefly about is the process of actually incorporating your business. In my opinion, the process of incorporating a business is actually not very complicated. What is complicated is all of the filings and obligations that come afterward. And once again, this is another case where the term jurisdiction is extremely important. This page here is for the process of incorporating federally, and this page is for the process of incorporating provincially in Ontario. There are a lot of things to consider when deciding where to incorporate your business, but generally speaking, you probably want to incorporate your business in the same jurisdiction where you do sales. Now, if you ever end up involved in a civil legal process, you might find this situation overwhelming. You've probably heard of the many cynical stories that people have about spending hundreds of thousands of dollars on lawyers and legal bills. For complicated cases, it's not surprising that you could spend that much, especially when you hire a lawyer. Having actually been through the process of suing someone for money that they owed me, I can give my perspective on the process. From my perspective, a lot of the cost is actually borne through wasted time and stress. The prospect of spending untold amounts of money chasing someone around in court is often enough to deter people from even seeking justice at all. In this listing of court fees, you can see that the cost of requesting a default judgment is only $94. And if someone owes you a few $1,000s that you think you can actually recover, that might actually be worth it. And this here is an example of the form that you'd file to request a default judgment here in Ontario. And as you can see, this form is not exactly that complicated. Now, I said before that the cost of filing this form is $94. But if you hire a lawyer and get them to file this form for you, they'll probably charge you a couple $100s on top of that. But of course, the lawyer does this all day, and he knows exactly how the process works. He knows exactly how to fill the form out correctly and avoid costly legal mistakes. But if you have time to read up and understand the process, you might be able to get through simple filings like this on your own. And for cases where you have nothing to lose, like pursuing bad debts, it might be worth seeing how far you can get. However, you do have to keep in mind that you're interacting with a formal legal process. And if you make mistakes in that process, you'll have to suffer the consequences, which is why it's advisable to hire a lawyer. But of course, lawyers are expensive. Fortunately, there are a handful of free legal services that you can get in touch with, even for small businesses. Here's one that exists in Ontario, but you can check your own local area. In practice, I've also found that the clerks who actually work at the courthouse are extremely helpful. The court clerks who work at the courthouse are not allowed to give you specific advice on your court case for obvious reasons. However, in my experience, I found that the court clerks are very eager to help you. If you ask generic questions like, which type of form do I file for this type of motion, or what are the rules of process for this procedure, the court clerks will provide you with useful information that you can use for further research. Hopefully, you'll never end up needing to represent yourself in court. But if you do, here's a few things to think about. When you go in front of the judge, be prepared and know exactly what you want to ask for. You cannot ask a judge for legal advice. If a judge suddenly blurted out advice to one side or the other on how to win the case, that would be a problem for obvious reasons. Having said that, I think it's often the case that a judge may understand your situation better than you do. And they may actually want to help you out, but they can't say the words for you. The judge is not your adversary. In a lot of ways, I think a court hearing is a lot like a performance. Ideally, the role of the judge is to act as a sort of neutral mechanical computer that judges things, and your role in the process is just to say the magic words that trigger the judge into making the right decision. Lawyers know exactly what those magic words are, and they know what the process rules are. And if you don't know what the magic words or the process rules are, that'll get you into trouble. In my observation, everything about the legal process is designed around being expedient. So it's very important to be respectful of the court's time. On the day that I spent in civil court, I got to see some of the other people present their cases. And from what I saw, almost everyone presenting their case was very disorganized. Many people weren't following the process rules for properly serving documents, and the majority of the cases on the judge's docket weren't even heard that day. They were simply adjourned to the future because they weren't prepared. If you put yourself in the shoes of a judge, I would imagine that over time, judges probably become very jaded and end up asking themselves this question before every new case. At least one of the people on this case is a disorganized idiot who I'm going to rule against. Which one is it? And if you don't understand the process rules, they might assume that it's you. Having said that, I do think that some judges grant considerable leeway to people who are self-represented due to financial issues, as long as they're acting in good faith. If the legal issue that you have is quite simple, winning your case might just come down to saying the right magic words. For example, you might ask the judge, "Your Honor, I would like to have the default judgment set aside because I have not been properly served," and that might be all you need to do to win your case. But if you go on a 15-minute rant about how society is going downhill and how everything is screwed up since your least favorite politician won, then you might still lose the case, even if the same information is deeply buried inside your rant somewhere. If you do end up winning a judgment against someone who owes you money, you may eventually end up obtaining a writ. If you've ever heard of someone having their property repossessed due to bad debts, most likely a writ is involved. If the person who owes you money has no cash to pay you, you can go to the court and obtain a writ of possession for their assets. If you find this topic interesting, you might also be interested in this British TV series called Can't Pay, We'll Take It Away. This series shows the on-the-ground reality of what actually happens during very late-stage debt enforcement.